At 2 a.m., District of Columbia police officers are dispatched to report of a suspicious vehicle. On arrival, they see two flee from the car. The runners left at least one of the vehicle's doors open. As Officer Vanderpool approached the car, the driver began backing out of the parking space while leaving the rear driver's side door open. The officer ordered the driver to put his hands up at gunpoint. When an officer orders a person to put their hands up at gunpoint, that is a constitutional seizure. The Supreme Court of the United States recently reversed the appellate decision and ruled that in District of Columbia versus RW, at that moment, the officer had ample reasonable articulable suspicion based on the totality of the circumstances. The totality of the circumstances requires courts to consider the whole picture. The officer had received a radio dispatch regarding a suspicious vehicle at a specified address. The officer saw two persons fleeing from a vehicle. Upon his arrival, it was almost 2 a.m., and as the officer approached, the car began backing out of the parking space while the rear driver's side door was still open. After watching two people flee from a suspicious car, a reasonable officer would certainly question the driver's next move. Reasonable suspicion need not rule out the possibility of innocent conduct. Based on everything that the officer observed, he drew the common sense inference that all three people in the car, including the driver, were trying to hide wrongdoing from the police. Reasonable suspicion arises when, based on the totality of the circumstances, the detaining officer had a particularized and objective basis for suspecting criminal wrongdoing, and depends on the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. The totality of the circumstances analysis precludes the evaluation and rejection of factors in isolation from each other. Because the DC Court of Appeals departed from those principles, and because Officer Vanderpool clearly had reasonable suspicion to stop RW, the judgment of the DC Court of Appeals granting the motion to suppress is reversed. This is a great example of why officers need to ensure that they pick up on all of the relevant factors on scene, articulate those objective facts in their reports, and are prepared to testify to the totality of the circumstances to ensure a conviction. Thank you, Officer Vanderpool, for all that you did on that night and all that you continue to do to keep our neighborhoods safe. To all the officers, stay safe. Subscribe for more.